Yes, I salute you all, and basically today the major topic is, and one of the key topics, the fundamental topics that we are going to look at is about fixtures and what? And chattels in land law. This topic, once you don't understand it, land law becomes hard for you. But what you have to know is, or what you have to bear in mind is the topic of fixtures and chattels. This is the key topic that we all have to understand so that we can understand land law topics ahead of us. So basically, I will start with a brief. I will first analyze how we can understand fixtures and chattels. Fixtures and chattels, the first difference that I can give is that a fixture is something that is attached to the land, whereas a chattel is something that is movable. For a fixture, sometimes it is not movable. It is attached inside to the land. And the good example of a fixture is a house. That is a fixture because it is normally attached to the what? To the ground. But a chattel is something that is movable, that you can move it easily. The good example that I can use is that a chair, these chairs, the tables, those are fixed. They are chattels. They are movable. You can move it from one place to another without damaging the what? The land. But the good example of a fixture is what? Is a house. You get? And basically, I'll start with the fixture. Basically, a fixture is something that is attached to land, so as it becomes part of it. You get? Anything attached to the land becomes land. That's what you have to bear in mind. Anything attached to land becomes land. And there's a maxim that says that solo planta, it is quidi planta solo sedit. That is the maxim. Quidi planta solo sedit, which says that whatever is attached to the soil becomes part of it. Whatever is attached to the soil becomes part of it, which means every fixture becomes part of land. What do I mean that becomes part of land? If you are selling something, let me give a clear example on what this maxim is trying to portray. For example, if you sell land and that land has a house on it, but unknowingly just say that you sell land, not bearing in mind that I have to also add the what? The sum of money of the what? Of the house. You sell land. Then afterwards, selling land, you tell the customer who has bought land, you say that what and what, I had the house, what and what, you also give me money in it. Basically, there the law will come in to say that anything that attached to the land becomes part of land, which means you sold the land and the house also was part of the what? Of the land, which means you cannot recover the costs of your what? Of your house. The good example is in the case of Francis versus Imbitonye. In Bitonye, under this case, the plaintiff built a house on the defendant's land without his what? His consent. And this plaintiff had also paid 26 pounds on account to get the what? The land. But however, he had not got any what? Any written consent of the defendant about the sale. Then afterwards, the plaintiff, the defendant refused to do what? To pay. Refused to sell his land, on which the plaintiff had constructed the house there, refused to sell the what? The house. Then afterwards, the plaintiff claimed the cost of the erection of the what? Of the house. Then the issue was whether the house had become part of the land and whether the plaintiff could recover the sum what? Paid. The court held that the house had become part of the land and the plaintiff could not recover any costs for building of the house because applying the principle of quidi planta solo sedit, though the plaintiff, this principle says that anything that attached to the land becomes part of the land, which means the plaintiff constructing a house on the defendant's land, that house had become part of the land, of which the land is for the defendant. Hope we are clear. The land is for the defendant, which means the house had become had become the defendant had become the owner of the house because he was the owner of the land. So basically here the plaintiff was only entitled to recover his 26 pounds he had paid for the transaction, but he could not recover for the costs for the erection of the what? Of the house. So basically, and also there are two elements that are considered under during weighing what is a fixture and what is a chattel. There are two elements. The first one is the degree of annexation, and the second one is the purpose for the annexation. You get? Remember, there are certain fixtures that can become a chattel, and there are certain fixtures that can be removed from land by the tenant. You get? By the tenant. So here, basically, we have seen there are two elements. We have the degree of annexation. The degree of annexation, they mean that how has it penetrated? How many feet has that particular chattel penetrated into the what? Into the land. And also when you look at the purpose of annexation, the penetration of that chattel into the land, what was its purpose? What was its purpose basically? You get? Was it a temporary or permanent? You get? Then the degree, could it damage the land once it is removed or not? So those are the things that we are going to look at. And basically I will start before going further details on those elements, I look on what is a chattel. A chattel is something that is movable, that can be moved from what? From land without damaging what? Without damaging what? The land. You get? Hope we are clear on that. Then here we shall see the case. The good case is the case of High versus Taylor. The case of High versus Taylor realized that the tenant had put valuable tapestries in a drawing room. Tapestries, they are like things that can make a room. They are normally put on walls. They make a room to look good. They are normally they are like crafts, but they are normally put on the what? On the wall, so that the wall can look what? Good. So here the tenant had put those valuable tapestries into the drawing room. So as he was moving, he removed them, but the landlord was like they were fixtures. You get? So here we shall look at the purpose for annexation. You get the purpose. Here the court held that the putting of the tapestries on the drawing room, the intention wasn't to make them part of the what? Of the house, but they were attached to enable them for the better enjoyment. You understand? For better enjoyment as ornament, what? To decorate, to make something colorful. For better enjoyment, you get something which is fixed for better enjoyment. We shall look at the purpose of what? Annexation. The purpose of annexation, basically what I mean is that we shall look what is the purpose. It is for better enjoyment. Another example I use for the DSTV dishes. These DSTV dishes, they are normally attached on the house. Remember, we say that anything attached to the land becomes part of the land. But those DSTV dishes are put for better what? Enjoyment. Which means if you are a tenant and you are going, understand, you can remove them and go with them. Those are your tenant what? Fixtures. They are there for the purpose of annexation. They are for better enjoyment. You understand? So basically, that's one of the things that I will do what? That I will put for the purpose of what? Annexation. You get the purpose of annexation. And also what you have to bear in mind is that not everything that is, you look at the purpose. Was it for better enjoyment? We have seen many people are putting TVs on the wall. So which means the essence of putting the TV on the wall is for better enjoyment. Which means if you are living or you are vacating the premises, you can remove it and go with what? With it. Because you put it there for better enjoyment, not for it to become part of the what? Not it to become part of the house. So basically, that also is key. Then when you go to the purpose, we have seen the purpose of annexation, then the degree of annexation, the purpose. Then when you go to also to still under the purpose of annexation, the purpose of annexation. The purpose, we shall see that if you have annexed something for a temporary use, you can also remove it and you go with it as a tenant what? Fixture. It becomes a chattel indirectly. It becomes what? A chattel. Once it is there for temporary what? For temporary use. Basically it becomes what? A chattel. Something that can be movable. I'll use some of the cases that give the difference between the two. There's the case of Lyon and Company versus London City and Midland Bank. Under this case, chairs were hired and fastened to the floor of a cinema. You get, with the screws. And once they were hired and put on the screws in the cinema, it was held that they remained chattels despite the fact that their annexation to the land had only been installed for a temporary duration of 12 weeks. You get, so the intention was temporary. So they became chattels. You get, so the intention is also key, and they were easily removed without causing damage to the what? To the premises. That is when you talk about the degree of annexation. They can be removed without causing damage to the premises or to land. Also, we have to bear that in what? In mind. Then there is also the case that gives the difference is the case of Vaudenville Electric Cinema Limited versus Morissette. Under this case, still it was cinema chairs. They were attached to the floor with screws. But here the court held that they had become fixtures on ground that they were placed in the cinema hall for a purpose of permanent use. You get, their purpose wasn't temporary, but was for a permanent use. You understand? Now here we are looking at the purpose of annexation. We have seen better enjoyment, we have seen temporary use. You get, once there is temporary use and there is the better enjoyment, they become chattels. But once the use is temporary, is permanent, they become fixtures. You get, so basically here we have seen the difference between the what? The two. Then there is the degree of annexation. The degree of annexation, they want you to show that if those chattels are removed, would they damage the what? The land. Anything that damages the land, it becomes a fixture. Either you are supposed to pay damages to the what? To the landowner. You get. So basically, note that in key. Then when you go to their chattels that are resting on land, you get, chattels that are resting on land, they can be removed. That is the general rule. A chattel that is not attached to land retains its status as a chattel. You get, when you read the case of Holland versus Hodgson, whereby they say that articles not otherwise attached to the land than by their own weight are not to be considered as part of the what? Of land, because they are resting on land by their own what? By their own weight. You get, by their own weight, which means they are not what? Attached to the land. Then there is an exemption to that general rule, whereby they say that however much a chattel, sometimes it is resting on land by its own weight, sometimes it can become what? A fixture. How can it become a fixture? Whereby if that chattel, let me use a case. There is a case of Hamp versus Bygrave. The case of Hamp versus Bygrave realized that these were vendors of land, who removed a number of items from the land after entering the market. You get, they removed a number of items. And these included a store, a statue, and other ornaments. You get. But however, the court held that the items were fixtures. They were fixtures. Reason being, despite that they rested on their own weight, reason being that they formed part and parcel of the garden that had been installed to primarily improve the what? The land. That is the case of Hamp versus Bygrave. You get. So we shall also look at buildings. Buildings, under the general rules, is that buildings, they are the key fixtures. You get. And the good example of a fixture, they are the what? They are the buildings. You get. But however, some buildings, they say that a building that attains its, like for instance, we see these containers that are normally resting on the what? On a concrete. You get, on the concrete. Could they be a chattel or a fixture? It is two-way. It becomes a chattel. Once it's removal, it does not destruct what? Destruct the land or destroy the what? The land. That is the degree of what? Annexation. You get. You read the case of Webb versus Frank Brevis Limited. This is where that a house that had been placed on the concrete remained a chattel, so long as they held that it was removable. It was removable by the tenant, since it did not damage the what? The ground. But however, there is the case of Elitestone versus Morris. Under this case, it was still the same. This was a bungalow that rested on concrete. You get, on its own weight. But however, the court held that this bungalow had become part of the land because it could not be taken and re-elected elsewhere without demolishing. You get, demolishing basically here gives you that in this fact it could bring damage to the what? To the land. That's why it became part of the land and it was regarded as a what? As a fixture. You get. So we shall go to the tenant's right to remove fixtures, or the right to remove fixtures. You get. Basically here what you have to know, or what you have to bear in mind, is that relate to section 37 clause 1, section 37 subsection 1b of the Land Act, basically. And here we have a classic rule under right to remove fixtures, or the tenant is right to remove fixtures. We have the classic rule that where a person fixes a thing or a chattel on one's land or a building on the land in such a way that it's a fixture by law, it becomes part of the land. It becomes part of the land, and the owner of the land becomes the owner of it. You get. And the landowner has no legal obligation to compensate the person who attached that thing on his what? On his land. We shall relate to the case of Francis versus Mbitoni, that case that we discussed at our introduction of this series. The case of Francis versus Mbitoni, whereby the other one constructed a house on the landlord's land without his consent. Court refused to compensate him because the house had become part of the land, and the owner of the land had become the owner of that house. You get, following the rule of quidi quidi, plante solo solo sedit. Anything attached to the land becomes part of the what? Of the land. You get, as we have seen there. Then, but however, they say that sometimes equity must apply. Sometimes equity applies. You get, applies to give a remedy. To give a remedy to the other what? To the other party. What do I mean by a remedy? Or what do I mean by having some equity intervention to the other party? Here comes in, or there are basically two grounds whereby a remedy comes in of equity. One of it that comes in is that where a person spends money or does something mistakenly believing that the subject land belongs to him and is authorized by the landowner. That is mistakenly. Another one is where the true owner must be aware that the material time that the land belongs to him and the other person is mistakenly doing something on his land. Where the landowner gets to know and keeps quiet, you get, and that's where equity intervenes. That's where equity intervenes. So we shall use the case of Babe Hunga versus Karejesa. Barehunga versus Karejesa. Under this case, we see that the respondent constructed a number of houses on the appellant's land without his consent. The court found that the appellant was aware and acquiescent and aware to the respondent's building of his land. You understand? So it held that the respondent had an equitable right to be on the on the land. You get? And there's also a good case of Musoke Bafirawala versus Goje. Musoke Bafirawala versus Goje of 1976. Here we see that the High Court ordered the landowner to pay compensation to the defendant for the improvements. Here we see that the defendant went abroad and left his building to the to the plaintiff to collect some rent, basically. But in the due course, he left with him for over 10 years and above, and the plaintiff constructed other buildings. So when the plaintiff returned, he instituted proceedings for the defendant to vacate the buildings. But however, the court held that the defendant must be compensated for for the developments made on the improvements made on on the land, because he had constructed more 10 buildings on his land, because he went abroad and overdelayed there. So there was equity interventions. You get? Hope we are on the same page. Then, meanwhile, we also have what they call the special situations of removal of fixtures. What we can also mean as the tenant is fixtures. You get? When can you remove a fixture? One of it is the tenant's right to remove ornamental domestic fixtures. You get? Ornamental domestic fixtures, which, for example, the tapestries. Don't think that are ornamental. Tapestries. For example, you have the case of Spider versus Philipson. Under this case, the plaintiff had installed a teak panel in the room of a house to give it a Jacobean appearance, and it was held that he was entitled to remove it because it was attached by screws and it was readily removable. Those are rights to remove ornamental domestic fixtures like tapestries. Then we have the tenant's right to remove trade fixtures. Trade fixtures, what I mean is that, for example, if you are a shopkeeper, there are those shelves that you put in someone's room to carry out your business. So once you are vacating, you have that right to remove those shelves. However much they are fixed to the house, which is the land. You get? There's a case of Smith versus City Petroleum. You get? The case of Smith versus City Petroleum, the plaintiff, who was the landlord, lent property to the tenant. The tenant placed upon the premises petrol pumps and tanks. You get? As he was moving, he wanted to remove the pumps and those tanks. You get? The old tenant the tenant that had gone, or that was, the tenant had gone, did not exercise his right to remove the To remove the pumps within the reasonable time. You get? Then the defendant removed the pumps, and the tenants his tenants came to to an end. In action, indemnity. You get? The issue was whether the pumps were tenants or landlord's fixtures. it was held that the petrol pumps embedded in the ground are tenant's what? Fixtures, and are removable within a reasonable time after the termination of the what? Of the term. If not so removed, the property in the pumps passes to the landlord, and subsequent tenant takes no interest in them. You get this case. Basically here it is the tenant who put pumps and tanks, but after going he didn't exercise his right. Then the landlord removed them. You get. Then claiming here, when he came back claiming, the court held that you must have removed them in a reasonable time. Failure to do them, they become property for the landlord. You get. But not the subsequent what? Tenant who comes after the old one. You get. So in this essence is that, let me give, if it is a lease, you must have removed them immediately your lease what? Expires. Once you exit, they become, the landlord is what? The landlord is tenants. You get. Then we also have agricultural fixtures. What do they mean by agricultural fixtures? Agricultural fixtures, basically, if, take for instance, it is a garden, we all know that gardenings, they put what? Maize, what and what. You are free to remove all your plantations, even if it is trees, even if they are plants, what and what, you can remove them, all of them, because those are your tenants' what? Fixtures. However much they are attached in the what? In the ground, but you can remove them. Flowers, you can remove their agricultural what? Fixtures. There is a case of Elwes versus Moores. Elwes versus Moores of 1908. In this case, we realized that a tenant was a farmer. He built a beast house, and the carpenter's what? Shed, a fuel house, a wagon house, among others, for agricultural purposes, which he removed before the lapse of his lease. You get. Then the landlord sought to recover damages for the removal, and the farmer was made liable to pay damages to the landlord for such removal at common law. But for equity comes in. You understand? However, the other one, the case was of 1902. Then, however, in 1901, the case of Mears versus Calendar of 1901, the right to remove agricultural fixtures was authorized following equity. You get. That is the case of Mears versus Calendar. You get. Actually, that's what I can talk about, and this topic is key. It is key of fixtures and chattels for you to understand what they mean by what? By land law. You get. That's it. Thank you for listening. Any topic that you feel that, any area that you feel that you haven't got satisfied of, put it in what? In the comment section. Thank you very much. Thank you for watching.